So, first question, Ken, please tell us about yourself and your practice.
Okay, I started my pupillage and I started practice also in Shuklin and Bok. For the first, I'd say about a decade and a half, I took on a variety of matters, all kinds of matters, including criminal cases. And then I developed a few areas of specialty. The first is civil and commercial litigation, what I call mainly business law litigation. Then there is the intellectual property area. I do the advisory and litigation part of intellectual property law, and then some arbitration and SIPA adjudication.
Right. Did you have a mentor in your formative years at the bar?
Not one mentor, but if I were to talk about counsel whom I've learned from in person, I'd say Boris Royan and Dr. Cyrus Das. They're both consummate professionals. From Boris, I learned how to analyze a case and to strategize. And from Dr. Cyrus Das, I learned how important it is to do written submissions well. Because I remember how he, for appeals especially to the Court of Appeal, how he would sit there with his secretary and for the whole day just dictate submissions and going over it over and over again and amending it and editing it. So, and the clarity of his writing is exemplary. So these are the two persons I'd say that I've learned from. Not in person, I'd say, especially in the writing aspect, is Lord Denning. Plain English, very easily comprehensible. So I've learned a lot from reading Denning's judgment and more so from his books, his series of books.
Yeah. You mentioned written submissions just then, Ken. Do you think written submissions serve an important function in today's advocacy?
Oh, very important. It's very, very important because you could win or lose your case just on the strength of your written work. And also realize that written submissions go in first, right? It gets read first by the judge before the judge even hears you orally. So another aspect is post-hearing or post-trial. If a decision is reserved, your written submissions serve as the reminder to the judge as to what your submissions are, what your arguments are. It also serves as a reference point for the judge to go back and read what you've actually submitted. So I think the importance of written submissions is getting more and more prominent now. It's more and more important to do your written work well.
I think it's become a lot more prominent now, Ken, because many years ago, even some post-trial submissions were done orally. But I think to save time and so that the judge isn't sitting there for hours listening to post-trial submissions, they always say put in written submissions. So in that sense, it's become really the order of the day instead of a lot of oral submissions.
Yeah, it's very important. I would dare say that written submissions, if not as important as oral submissions, it's even more important than oral submissions for the reasons that I've pointed out. So our written work, we must develop our writing skills, and writing in the context of written submissions, and of course submissions in reply, and to some extent also your affidavit work. I think your drafting, I think it's very, very important in modern practice.
Ken, what steps do you think should be taken before one starts drafting a written submission?
Okay, let's talk about application first, all right? written submissions for application. So you must know the facts from the affidavits and from the exhibits. And then you need to identify the issues. When you identify the issues, you need to also decide how you're going to win on the issues. So you formulate your arguments. And then you do your research also concurrently. The research, of course, is to support your arguments and also to support your reply or your response to your opponent. And then next, you plan. You plan what you want to write. That's a step that you cannot skip. You don't just draft from arbitrarily or randomly. There's no randomness to it at all. You must plan everything out, structure your arguments. Then you start drafting. And then after drafting, very importantly, you must edit your work. So that's application proceedings. For trial, I would say that you have to know your pleadings inside out. Whether you're plaintiff or defendant, you have to know the notes of evidence. You have to know the documents, the documentary evidence. And then the same process starts and ends. You have to identify the issues and how you want the issues to be answered in your favor. So you work out your arguments. And then concurrently, you're doing your research in order to support your arguments. And then before you draft, you plan. After you're happy with your planning, you start drafting. And after you draft, you must edit. Always edit your work. Make it better. Make it more brief. And then on appeals, you have to start preparing for appeals from the word go. So quickly get the grounds of judgment, analyze it. You have to prepare your memorandum, and of course your clerical staff, and with your supervision, must carefully prepare the record of appeal, and all within time, of course. Write the necessary letters to all the parties to the court. Then you identify your issues, same process. Identify the issues and then decide how you want those issues to be answered in your favor. And you do your research concurrently. And for appeals, don't forget the threshold for appellate intervention. Right, that's an additional aspect that is not there for trials and for application hearings. And then you plan, you draft, and you edit.
And Ken, I mean, that's a very comprehensive list of things to do. How long would you say you should give yourself before the deadline to start planning your submissions?
Right. I worked out a kind of a principle or a mantra to work by, which the firm, everyone in the firm actually follows. I realized that people work faster, harder, more efficiently when you're under stress a little bit. When you're cornered, it's the cramming before exam syndrome, and on the 13th day of the affidavit, when the affidavit is due, on the 14th day you start panicking, and then you start working on it. But that kind of working actually brings out the best in you. Okay, there's a law for it. I think it's called Pareto's, Pareto, Pareto's law, if I'm not mistaken. So I get that principle, and I also get the principle of Parkinson's law. Parkinson's law says something like this: for human beings, when you're pushed into a corner, you will do your best. The best comes out of you when you're under stress. So what I do is, let's take a 14-day period for the filing of either written submissions or affidavits. I tell my lawyers, sweep it around, give yourself a 4-day, for example, a 4-day time limit. So you've got 4 days to finish your submissions at the start. So then the rest of the time, the 10 days that is left, is what I call grace time. And with that grace time, you cater for things going wrong. You want to change your arguments. You want to improve on your arguments. You want to edit your arguments even more, or your written submissions even more. That's the time to do it. Because if you're on your 13th or 14th day, you don't have that grace time. And it's also less stressful working that way, because you are almost artificially putting yourself in an urgent situation. You're giving yourself 4 days instead of the 14 that you have. So you try to simulate for yourself, it's the last 4 days. I have to get this done in the 4 days. And but you know that it's just a simulation. So although you are giving your best, you're under a little bit of stress, but it's not the kind of stress that you would face as if you're doing it on the eve of your deadline. So hopefully better work comes out of you, and you have so much more time to spare, and the grace time, and you're sitting easy after you finished it. You can edit your work. You can make sure you've got so much time to improve the work. You can even give your submissions to one of your colleagues who's not working on the file with you to independently read it, to see how you can improve it again. Because at the end of the day, what we want is we want to deliver work of the highest quality, right? We want your submissions to be the best that it can be. And if you leave work to the last minute, it just can't be that naturally. So I hope that answers your question, Ray.
Oh, it does. That's very helpful. You mentioned being in a stressful situation when drafting a submission. What would you say is the best environment to be in when drafting a submission? And by environment, I mean either being alone, drafting in solitude, or maybe drafting as a team. Which would you say is the best environment to be in?
Right.
Drafting.
If alone, you can't afford to work only on your written submissions for 3 consecutive days, right? Because we've got other work to do, and we've got our dailies, phone calls you have to make, emails you have to respond to, and so on. So invariably, you have to draft your written submissions in parts or gradually. Okay. So what I would do would be to carve out, say, 3 hours in this day, and 3 hours every day until I finish. And I give myself a deadline also to finish. For example, 4 days, exclusively for drafting. The rest of the time, I'm doing other work. Now, there is an advantage to drafting in parts. That advantage is this: in your editing. Because if you are editing right after you finish your draft, let's say you made an error or you made mistakes, right? If you read it immediately, you edit it immediately, chances are you might miss out on some of the errors that you've made because you have just done it a few minutes ago, So if you let time pass between your editing and your drafting, you will tend to edit better. So it's more efficient editing. So that's one of the advantages of drafting in parts. But I think in modern practice, you have to draft in parts. I can't remember a time when I could actually sit down for 2 days and actually finish off submissions exclusively, you just can't do it in modern practice. You have to draft in parts. Now, in a team situation, I would say one person draft. I think if 2 persons were to draft at the same time, sitting down, dictating, one person keying in, another person dictating, I don't think that, I think it's counterproductive. I think it's better if we have one person draft. But if you're working in a team, you can edit as a team, right? Everybody can contribute as to how to make your arguments better, how to shorten your sentences, or the sequence of your points, the way it comes out. If you want to quote extracts from cases, maybe somebody has a view that you should quote not the whole part of it, but maybe you can quote a smaller part of that extract or that paragraph of the judgment, or even expand upon it. Maybe this is not enough. Let's quote from another passage from the same case or something. So when you're editing, you can do it as a team. So I think drafting is better one person draft.
Yes, I have another question. Something that happens to be occasionally writer's block when drafting. It actually more than occasionally, pretty often. What are your suggestions on how a draftsman can overcome writer's block?
Right. If you have a plan, you shouldn't have writer's block because you already know what you want to say, right? So what I do is I have what I call a first step session with my team or the other person who's working with me on the file. We have at least two persons working on any case, any file, because two minds applying themselves to a problem or an issue is always better than one. So we have a first step session. In this first step session, we discuss and decide on what points we want to make and the order of those points, right? And then we decide on the headings as well. So the headings are the actual points that you want to make, right? Before you even draft. So if you have this first step session, you've decided on the points that you want to make and the order of it. And you've even decided on, say, the headings, which will be the impetus for you to elaborate on the heading. Then you can minimize writer's block. But I'm mindful of a saying: writing begets writing. For those of you who don't know, begets means give birth to. So writing begets writing. You just have to do it. You must have the discipline to just sit down. You've allocated time for it. You just do it. You deal with the mistakes and the errors and things not coming out the right way with your editing. Yeah. Maybe I should just elaborate a little bit about headings, because I think that's a very important aspect of modern written advocacy. I think we have to change the way we write for written submissions. In academia writing and legal writing in general, like article writing, for instance, you are actually leading to your conclusion. But for written submissions, you must lead with your conclusions. Okay, what I mean by that is this: you must conclude first. So you have a heading, your next paragraph is your conclusion. Before you even start to explain, your next paragraph is your conclusion, the point that you want to make. And then only you start to elaborate. And you elaborate by showing the reader, who is the judge, how you get to your conclusion. Why did you conclude the way you've concluded? And then after you've elaborated or explained, you conclude again. So you're actually making your point 3 times, by way of your headings, by the first paragraph that happens after your headings, and at the end of that section of that heading. Okay, I've got some examples of headings there. Let's say you're trying to make a point about breach of contract, right? If you have the heading contract law, like in a textbook or something, it's too general. You end up talking about the elements of contract law, the formation of the contract, and so on. You have a temptation to do that because your heading tells you contract law. That's all unnecessary. So the next heading that I have here as an example is breach of contract. That's your point. That's what you want to make. But I feel that is still too general. Okay. Then the next one down is more specific. It says defendant's breach of contract. That's a better heading than the first two. But I'm thinking that you can make it even better by using the active voice. So you can change it to the 4th heading there, which is defendant breached the contract. So that's writing in the active voice. It's even better than the 3rd. And then on top of that, you can make it even better by saying defendant breached clause 3 of the contract. So it's even more specific. And then you can straight away zoom in, straight away write about clause 3 and how the defendant has breached it. But even better than that, you can have an entire point as your heading, which is defendant breached the contract by failing to deliver the goods. It's to the point. The reader, the judge, will read your next paragraph. He or she already knows what you're going to talk about.
Yeah, no, that's really helpful, Ken. If I could just move on to another issue, which is how best to structure a written submission. What would your advice on that be?
Okay. I always start with an introduction, but my introduction is not just like this is a case between the plaintiff and the defendant where the plaintiff is claiming 3 million ringgit. This case is about the breach of contract. That's harmless, that's innocuous, it doesn't help you. So I try to include my main conclusion in the introduction itself. It could be what type of case it is and how you want the judge to think. Just reading your introduction, you're already leading the judge to your conclusions. So I try to include a conclusion, like an ultimate conclusion, in summary form, 1 or 2 paragraphs, right, in the introduction itself. Okay. Then I would have important facts or background facts, depending on how you want to make that as a heading. But then again, don't be a slave to chronology, Usually people put down the facts in chronological order. I mean, that's not going to help you. You probably already have a chronology all set out in, for the trial, before the trial. So you can get an edge out of setting out your facts by setting out the facts in the context of what you want to argue. You can emphasize the facts that you want to rely on, the facts that support your arguments. Okay, you don't have to plead the whole matrix of the facts of the case. You don't have to. This is your written submissions. You are in control of what you say. So I would prepare facts that help the judge understand how I get to my conclusion, what my arguments are. Okay. Then next, point by point, heading by heading. Sometimes, quite often nowadays, you have subheadings. So you make your points that way. And then at the end, you have an ultimate conclusion. And the ultimate conclusion, I try not to have to say, in the circumstances, the plaintiff prays that the plaintiff's prayers in paragraph 1 to 10 be granted with costs. I mean, that's not, to me, that's not a conclusion. That's the end of a statement of claim, so to speak. You should have a conclusion that is like a real conclusion, Your entire submissions come down to those 2 or 3 paragraphs in your conclusion. That's how my structure is, the basic structure.
Sure. You spoke a little bit about the facts part of the submission, and you mentioned that it'll be good to kind of structure it in a way that supports your case. Would your advice be different if we are acting for the plaintiff as opposed to us acting for the defendant? Is there a different way to set out the facts depending on who you're acting for, plaintiff?
Okay. I think I would start with, you would start with this thought, right? You would start with the thought that you can't draft your facts until you know what your arguments are. When you know your arguments, you know what facts to emphasize, and you know how you want to say them. Okay? When you know your arguments, you know what is the story that you want to tell. Now, in terms of acting for the plaintiff and the defendant, maybe I should respond in this way. When I'm drafting the facts, I want to do it in such a way that I'm thinking, what do I want the judge to think after the judge reads my facts? So if I'm acting for the plaintiff, I want the judge to be thinking this after he reads my facts. And that is, this is what the defendant has done to the plaintiff. If I act for the defendant, I would want the judge to think, after reading my facts, the plaintiff has dragged the defendant to court when he shouldn't have. Another principle that I use when I'm drafting facts is whether you act for the defendant or plaintiff, is lead with your strongest facts, your most important facts, right? Most important to the argument that you want to make. What I mean by strongest facts are facts that leave an impression.
If I can just move on to reply submissions. I've always thought that drafting a reply submission is, of course, one adopts a different approach to drafting that type of submission as compared to a principal submission. What would you say are the effective ways for drafting a reply submission?
The method that I use is to make reply submissions stand alone, so that the judge doesn't have to refer back to your opponent's initial written submissions, which you're replying to. But I'm not saying that you should regurgitate your opponent's argument, right? What you would do in order to get the edge and in order to get control is you would set out in your own words what your opponent is submitting, and then lead to your reply. And because you're setting out your opponent's point in your own way, you can see the advantage that you would have when you're replying to it, because you're controlling the meaning of his points, his arguments. And then when you reply to those points by your opponent, the judge can then see all in your one document without having to refer back to your opponent's written submissions, right? So that's the way to make it smooth and easier for the judge. And the advantage of that, I think, is you control what your opponent is even saying. Of course, you must be accurate about it, but what I'm saying is that you do have that power to set out your opponent's arguments in your own words. And then when you reply to it, you can see that there's more room for you to move, so to speak, or you know what aspect of that argument you can emphasize in your reply.
Sure, that's really helpful. And insofar as the order of your submissions in a reply submission is concerned, do you follow the order adopted by the plaintiff, or do you just sort of adopt your own order? Okay,
I would rank their points. So their most cogent or their biggest point, their strongest point, I would address first, right? Knowing, of course, that you are hoping that the judge will read your submissions in reply and can understand it easily also. Because one of the factors, one of the truths of current legal practice is judges really don't have time. They don't read your submissions or your submissions in reply word for word, you know. They skim. So if you follow your opponent's order of the points, I think you're not taking advantage of the situation. You might not get to the strongest point, and the judge might have dropped off on your submissions in reply already. So the point here is to reply to your opponent's strongest points first. So it doesn't have to be in the order that they set it out.
Sure. Yeah, no, that's really helpful. Ken, earlier you spoke about the slightly different approach when planning for a written submission for an appeal as compared to something being heard first instance. Is there a difference in drafting written submissions for a first instance matter as compared to a set of submissions for an appeal?
I think that what you write about is different, but I think the objective and the purpose is the same, and that is to persuade the judge to find in your favor. So what you write about is different. The procedural law is different, trial compared to appeals. So if it is trial, written submissions, you'd have to analyze the notes of evidence and documentary evidence. You would use the evidence and the law to support your arguments. In an appeal, yes, you have to analyze the evidence, but more importantly, you have to analyze the grounds of judgment. You have to find errors in the grounds of judgment of the court of first instance. And you use the errors as well as the law in order to, and your record of appeal, of course, in order to support your arguments.
Sure. In terms of length of submissions, do you say that there is a marked difference between the two types of submissions?
Yeah, I think so. I think trial written submissions are much longer than appeals. I mean, you might find that to be counterintuitive, because when you're appealing against the entire trial, right? But actually not so, because once you're at appeals, to me anyway, everything is narrowed down. You already have a judgment. So what you're doing is something different entirely. You're actually trying to challenge, if you're appealing, you're trying to challenge the judge's reasoning in the context of all the evidence and the facts. So you have to know more, right? You have to be really familiar, as familiar, if not even more familiar with the evidence, the notes of evidence and all that when you're appealing. But I think the length of the written submissions for appeals should not be anywhere near the written submissions for a trial.
Ken, when I was growing up in Shuklin and Bok, sometimes you have partners tell you when you are filing written submissions for a motion in the appellate courts, and then they say everything you want to say in 5 pages. So say everything you want to say in 10 pages because the judges don't have time. I mean, what are your thoughts on limits like that? Do you think it's practical, or do you think it's advisable?
I think it is both practical and advisable. Yeah. You know, our rules, or is it practice directions, prescribe that if our submissions in the Court of Appeal goes over 30 pages, we're supposed to do an executive summary, right?
Yeah.
Right. But I don't follow the 30-page rule. If my submissions is 15 pages, I will still do an executive summary. Because one of the first things that the Court of Appeal judge picks up, and we know this from the horse's mouth, we know this from our friends who are on the bench.
Yes.
They tell us this. They pick up the executive summary. They pick up the grounds of judgment. They pick up your memorandum. That's what they read first. And then a 45-page written submission is staring them at the face. Which document do you think that they prefer? Your executive summary. Even if your submissions is 15 pages, which is half the prescribed 30-page rule, right? Have an executive summary there. It's also good practice, because writing an executive summary to me is like pre-C writing, when I say pre-C, I mean the word Precis, right? When I was in secondary school, I don't know about you guys, in the English language subject, under comprehension, there is a pre-C writing test. So they give you a document that has got, say, 500 words. When we were teenagers then, right? 500 words. And you're supposed to summarize that passage or those paragraphs into 100 words. And when I started when I started practicing law, I realized how important those skills that I learned in secondary school was. It's summarized writing. You're writing in summary. It's called pre-C writing. And that's what you should be doing anyway. So if you have a 15-page written submissions in the Court of Appeal, write an executive summary just for practice. It will put you in good stead.
Could I maybe just ask something fairly similar to what you just spoke about, which is writing styles? What would you say is a good writing style to adopt when drafting a written submission?
Why don't I talk about principles, right? If you follow these principles, maybe your style would be better, would be good. Right? The first principle is write in the active voice. As I tried to demonstrate just now with the breach of contract heading, writing in the active voice is like this. Instead of saying the ball was kicked by John, you say John kicked the ball. And when you write in the active voice, naturally you shorten your sentence because it doesn't have those two words of and by in it. Okay, whenever a sentence has of or by, that's writing in the passive. The ball was kicked by John. When you get rid of off and by, what I tell myself is every time my draft has got by and off in it, I try to see whether or not I can write in the active voice. I change my sentence. And quite often I find that it's more effective. It's smoother. It's stronger to read. And an added benefit is it makes your writing more brief. Okay, so that's one of the ways. The second principle I would say is to follow is lead with your strongest argument. That's always a good thing to incorporate into your style. You talk about the more important things first, because the judge might not get to your third point. Okay. The third is try to leave out adjectives and adverbs. Adjectives are words that describe a noun, and adverbs are words that describe the verb, an action, right? So adverbs usually have the word, the suffix ly at the end of it, like especially, or whenever you have a word with ly, that's probably an adverb. Of course, I don't know all these language rules and all that. I just picked it up along the way because we in Malaysia, we are not taught all these language rules when we are taught English. Let me give you an example of not using an adjective, right? The neighbor's renovation works destroyed the plaintiff's beautiful house. Beautiful is an adjective because it describes the house. But does the word beautiful have a place in what you're trying to say? You want to emphasize destroying the house, right? Not how beautiful the house is. So the word beautiful there is not necessary. Okay. Now let's talk about adverbs. I've seen a lot of pleadings that say something like this. The plaintiff's assertion is vehemently and strenuously denied. Vehemently and strenuously are adverbs. They're not necessary. No matter how vehemently or strenuously you deny it, it doesn't make a difference to the judge, really. So you can just say you deny it, right? It's more effective. The reader doesn't have to read more to understand what you are trying to say. Another style or principle is, I think the understated or low-key style is usually better. And the reason I say this is when your writing is understated, you are almost immediately more credible to the reader, to the judge. So an overall understated style in your written submissions is usually better than a dramatic one. Okay. Let me share screen and let me try to describe to you why I say so. This is dramatic writing with adjectives and adverbs in it, okay, which I feel is unnecessary. Words like this, phrases like this, completely wrong, absolutely unfounded, blatant violation, clearly baseless, certainly misconceived, obviously absurd, and vehemently and strenuously denied. Okay, let me turn on my camera again. Yeah, so no need to be dramatic. I think an understated style is good. Lastly, but not least, be brief. Be brief. I think we've already talked about how a judge skims through your written submissions because judges just don't have time to read things word for word. So it is better to write in such a way that you will catch the judge's attention fast. And being brief is one of the ways to achieving that.
If I can maybe just pick up on that last thing you mentioned about brevity, how do you think one could effectively balance the need to be brief against the required detail when making his or her point in a written submission?
I mean, knowing that judges skim through your written submissions and they don't read your submissions word for word, right? You should try to achieve conveying the maximum amount of information in the fewest number of words. Okay, so let's compare academia and practice. In academia, you're trying to take a 2-page argument and write 30 pages about it. But in practice, you try to turn a 30-page discourse into a 2-page summary. That's how you can be effectively brief. One of the ways to be brief is to replace phrases or a particular phrase with one word. Let me try to share screen to demonstrate that. Here are some of the examples of phrases that can be replaced with a word. For the reason that, what that phrase means is because. Due to the reason that also means because. Subsequent to can be replaced by after. Prior to can be replaced by before. At an earlier date can be replaced by previously. And in as much as can be replaced by sometimes since, sometimes by because. The same for this phrase, insofar as. And in view of the fact that can be replaced by since. And this is a monster of a phrase, notwithstanding the fact that. What that means is just although. And then pursuant to, like pursuant to section whatever or whatever act, right? You can just say under. Or in accordance with clause 5 or clause 3 of a contract, you can just say under clause 5, under clause 3.
Ken, that is really useful. I just took a screenshot of it.
I think we're all guilty of using
In this
such
regard.
language. Yeah.
And just imagine if you write like that indiscriminately,
Yeah.
your submissions will tend to be longer and longer, right?
Yeah.
Okay. And then another way is to drop what I call filler words. Okay, we write a lot. You know, we've got words and phrases that we wouldn't actually say in ordinary speech, and you wouldn't actually say it when we are orally submitting. You know, things like in the instant case. Another thing that comes to my mind is it would appear to be the case that, I mean, we will write that, right? But we won't say it. Another one is, it's interesting to note that. I mean, that's like academia writing. You have a lead up to it. You're throwing away all these words just to lead to what you're actually trying to say. So my response to that is, just say it. You don't need those words. You don't need to say, it would appear to be the case that this and that. It is interesting to note that this and that. I also don't often say, I respectfully submit. There's no real need to, But sometimes it fits in with the bigger picture. Then I would say, but I only occasionally write that, because you are submitting. You don't have to tell the judge who is reading your work, you are respectfully submitting it. Whatever you're writing after those few words is what your submissions are, right? So that's another way to be brief. Now, I'd like to say that words have a voice. I try to write what I want the judge to hear. I hope you know what I mean. Because readers, like judges, they absorb less the longer they have to read. The longer that your writing is, the harder it is to keep the reader's attention. And I know for a fact that many judges look at how many pages or how thick the written submissions are before they start reading the first paragraph, because it's a bit of a turn off for them, looking at submissions that are 60 pages long. And to their minds, it's a simple case. So try to write what you want the judge to hear. Don't write what you actually won't say or speak in oral submissions.
Thanks.
But that is not to say, caveat, right? That is not to say that you should write in point form. That's no can do. You must have full sentences and so on. There are ways to be brief without having to, just write in point form. Out of interest, now that we're talking about being brief, let me just share screen something with you. It's quite interesting. It's what I call the maybe redundant writing or redundant words, Let me try to find it. Yeah, I call this the example of too many ands. Let's try to read this sentence together. I would like to render and mention a special thanks and appreciation to all the members of the organization who have invested and gave much energy and effort to obtain and sustain the standards of services and professionalism expected and required by the authorities and the community. There are just too many ends here. There's no need. This can be shortened to a quarter of its length. Okay, I've got two quotes here. The American novelist Elmore Leonard, he said this: I try to leave out the parts that people tend to skip. And Robert Louis Stevenson, who wrote Treasure Island, he said this: there is but one art, and that is to omit. So yes, brevity is extremely important.
Thanks so much, Kenneth. That was really, really helpful. If I can maybe just move on to another important part of written arguments, that is the citing of cases. Is there, in your opinion, an effective way to cite a case? And also, whilst you're addressing that issue, would you be able to give us some advice on how best to use extracts from judgments in a written submission?
Citing cases, an example. Let's say the case is XYZ, Miriam Berhad and another, and John Smith and 12 others, and that's a citation there. In the body of my written submissions, I would say in XYZ and John Smith, the Court of Appeal held, and then I would put the paragraph number there, and you can see that I put a footnote at the end of it, and then the footnote would read PBOA, say Plaintiff's Bundle of Authorities, tab 7, And the full citation is here. Together with this Court of Appeal, because I think it's a good indication the level of the courts this case is at. Page 37, paragraph 57. And if I can use an example of how we should cite extracts from cases, I've just pulled out a page in one of the submissions that we did recently. This is how we do it. We set out the principle that we want to submit on first before we quote from the case, right? Very often you find that lawyers are quoting from the case and the reader is wondering, what is it about this case that, that the counsel wants the reader, the judge, to know about? So in order to look after that problem, what we do is we state first the principle or the point that we want to make, and then we quote the case in order to support our submission of that principle. So if you look at paragraph 29 here, the point that we want to make here is that the plaintiff's description of the documents sought from the defendant are too wide and lacking in certainty, and this tantamounts to a fishing expedition. And then we cite the case of C.I. Lumix, and we quote here, and then we put a footnote at the end to inform the judge where it can be found in the bundles and at what page. There is no paragraph number here because it's MLJU. So MLJU doesn't have paragraph numbers. You will also notice that certain words are bolded here. Let me say a few words about bolding. I've seen submissions come to me and they emphasize by bolding and underscoring and italicizing. And they underscore, italicize, and bold many words, an entire paragraph sometimes. That would just dilute the effect of all the bolding and the underlining and the and the italicizing that they're doing, right? So bold or underline or italicize sparingly, okay? Because if you, and also only use one mode. I feel that one mode is enough. You don't need to bold and underline, right? The bolding of it or the underlining of it is already sufficient emphasis placed. Is enough highlighting already to the reader, to the judge.
Just one more question before I open up the discussion to the floor. What would you say are the ways an advocate could effectively use a written submission to enhance the effect of the oral submission?
I think the mindset that you should have is to win with your written submissions. And I've already mentioned that to some extent, written submissions is becoming more important, if not just as important as oral submissions. Just to illustrate this point, one of our federal court judges, when he was in the Court of Appeal, told a few of us that he reads the record of appeal, he reads the written submissions of parties, and then he formulates an opinion before the hearing. And only in 15% of the time, the counsel is able to change his mind, which means 85% of the time, at least for this judge, and I think quite likely it also applies to other judges as well. For him, 85% of the time, he holds on to the opinion that he forms from reading your written submissions. So to answer your question, Greg, I think we should go in there with the mindset that we want to win with our written submissions. Not just to enhance our oral submissions or supplement. Of course, it does that. But I think with the importance of written submissions, you should divide your time up accordingly, and make sure that your written submissions are excellent.
If I can maybe just ask a follow-up question to that, and it may be me veering off to a different topic here, but would you say there is a way to use your written submission whilst you're delivering your oral submissions? Like, for instance, is there an effective way to perhaps refer to the written submission once you're submitting orally, or do you just not do that at all?
I hardly do that. When oral submissions, you are there almost with your point form notes, keywords, and when you're preparing for oral submissions, you are actually running through your mind, writing notes, rehearsing. You just want to make sure that it comes out better. How do I say this better? And because written submissions is all in long form, I hardly refer to the written submissions. Unless, of course, the judge is asking a question that relates to that, and you're actually pointing out a particular paragraph, I might go there of my written submissions. But generally speaking, yeah, you're trying to use another medium to persuade when you're doing oral submissions.
Sure. Thanks so much, Ken. That's really helpful. Jan, did you have any?
No, I did want to ask Ken this. You see a lot of people filing their written submissions, and there's always a need to write in what they feel all legal terms. You use Latin words or phrases, sorry, or big words, where you got to take a thesaurus out and figure out what the hell does that mean. Big language, big words to make it sound all floral and flowery. And, I personally feel I was trained to write short, simple sentences, not to assume that the judge is stupid, but just to make it easy. But a lot of people seem to think that that's a very simplistic style of drafting, and you need to throw in big words and, Latin phrases. What are your thoughts on that?
I think that clarity and coherence and brevity also trumps verbosity any day. And I hardly ever use the old English heretofore, herein, therein. I hardly even use the word therefore, because if you write well, if your writing is flowing, there's no need to use hence or therefore. It just comes naturally, and you can save a word there. Yeah, I don't use the plain English is better, because what you're trying to do is you're trying to be persuasive, right? You can't be persuasive if you're not clear. You can't be persuasive in this modern practice of, judges having to read pages and pages of submissions day in, day out. You can't be persuasive without being brief. So I think
that makes a lot of
clarity
sense.
Trumps all that.
Would you say that that's an older style of drafting?
Sure.
Or writing?
Yeah, sure. I used to write like that. I had to consciously change, because I see that it's becoming counterproductive.
Well, I'll ask Ken another question. When we were very junior and you have to start drafting submissions, whether it's post-trial, or particularly applications like an Order 14 application or an amendment application, and you don't know where to start, and you're meant to prepare a first draft, and then you ask your colleagues, do you have written submissions that you've done for an Order 14 application? Can I have a look at your precedent? What are your thoughts on that? We all did it. I did it in my first or second year, and even for post-trial submissions, just to get an idea of how to do it. I suppose there's a need for guidance, but what would you advise if you are actually doing that for guidance?
Okay, if you treat let's call it sample, from a more senior lawyer, or in the firm, you know, if you collect, if you catalog your opinions or your written submissions on any by area of law or something, then it's very good to have. But if you treat that sample like you do Atkins court forms, I think that's a good thing, right? But I think it's a bad thing if the young lawyer takes the copy and paste attitude to writing submissions. That's a no-no. We must customize everything. We must tailor every piece of work for its purpose. No two cases are the same, and you hardly want to use an authority for the same set of facts, identical set of facts. It's rare. So that being the case, by all means, you know, use the samples like you would Atkins for guidance, to know how to start. Maybe even look at the style. You know, try to follow the style if the writer is a very good writer. But certainly not copying and pasting and plagiarizing or something. You know, I think that's not right. If a young lawyer does that, he or she is only doing himself or herself a disservice. You won't develop skills that way. You will only develop skills, writing skills, by writing, by practicing writing. Can I offer another principle that also helps with your style?
Yes, please do.
Which I think is lacking nowadays. It's about visual aids, you know, visual tools, diagrams, charts, timelines. Because a picture paints 1,000 words, right? A one-page flow chart can convey more than 10 pages worth of words, you know, in a complex, say, corporate transaction. So use visual aids. When I do an IP matter, say, for example, a patent case, right, I have to use diagrams because I have to point out certain features of the actual patent or the product that came from the patent, and try to convince the court that there is infringement. So there's no way that I can, no good way that I can use words to do that. I need the judge and the reader to see it, to see the object. So visual tools are very important. It saves you a lot of words, a lot of pages. It helps you to be brief, and it certainly contributes to your clarity, right? The reader doesn't have to read 2 pages worth in order to know how the machine works, for instance, or what is the timeline, you know. I think it's very, very important.
Hadi, you had a question for Ken. Hadi?
Hi, Ken. Ken, first, I'll start by thanking you. I think so. I speak for everyone here. It was a great session. We've definitely learned a lot from our teachers today. But my question is on the analysis aspect in coming up with a written submission. Would you just like to expand on it a bit more? How does one carry out an analysis of whether it be the factual part of the case or the legal principles part of the case, the analytical aspects of the written submission?
Start with your arguments. You first have to decide what arguments or points you want to make, right? And then the analysis is to find if it's a trial, the notes of evidence, the portions of the notes of evidence that actually support that argument. And then when it comes to documentary evidence, you have to find the documents that support the argument. And in your research, you are finding authority to support your argument. So that's what I meant when I said analysis. You're analyzing the evidence, you're analyzing the law to make the argument that you want to make. But your starting point is, what are the arguments you want to make? You have to decide that first.
So just to summarize that, documentation, legal research, as well as the facts first lah. And that doesn't come in any particular order, Ken?
No, everything is, to me, all done concurrently.
All right. Thanks, Ken.
So
That's
your
all I have.
starting point is you work out the arguments that you want to make. Then, of course, you know the facts of the case. It's in the pleadings. Then the evidence must support your argument. So evidence come in two forms: oral testimony, notes of evidence,
Yes.
documentary evidence, which is in the bundles of documents, and then, of course, your research will disclose the authorities for the principle that supports the argument you want to make.
Yes. Thank you so much.
Thanks, Hari.
How do you suggest we deal, Ken, when you are drafting a post-trial submissions and you want to reproduce excerpts of the evidence, and you find that it could be chunks and chunks of evidence, it goes into pages, but you know, in it could be perhaps even 10 minutes of cross, and everything is in that meaty 10 minutes of cross. I mean, we've all seen post-trial submissions where everything is reproduced in cross-examination. Plaintiff's witness number 2 said this, and then it's like pages and pages. It's a bit of a put-off trying to read it, but how else can we reproduce it? Do you think an annexure saying can be seen at annexure 1 might be a better style of doing it, or do you just put it all down in like 5 pages of your written submissions?
Right. My preference is to have the written submissions post-trial to stand alone as well. So if I want to quote from the notes of evidence, for example, a particular portion of a cross-examination of a particular witness, right? The preference is to produce it in the body of your written submissions. But like you say, in your example, it could be 5 pages worth of notes of evidence that you are reproducing. That's too long, that's too much. So what I would do would be to put it in an annexure. So I would describe what I'm trying to get out of the quoting the notes of evidence. I would describe it first, and then I would refer. And then you would have an annexure that goes in together with your written submissions. That's also the method that you can use if you want to refer to actual documents. You don't just say in the body of your written submissions, ask the judge, please refer to bundle of documents, bundle enclosure 205, bundle B2, tab number 4 or documents you're talking about, page 250. And then expect the judge to actually dig out that bundle and look at it. So you will reproduce that page as part of your annexure. So it goes in together. So all the judge has to do is to refer to an annexure which is beside him. Or if he's reading your soft copy, he just has to open up that folder, which is the annexure. I think that's one of the ways to do it.
Yeah, I think it's important to bear in mind, Ken, and I mean, you've said this all through the 1 hour that we've spoken. When we're drafting written submissions, what we need to bear at the forefront of our mind is how is it simpler for the judge reading it?
Yes.
So if you're going to require the judge to look into volumes of documents, and there's a chance that they may say, look, I'm not going to bother to look, and you miss out on that chance. So it might be making the judge's life easier by putting it as an annexure or reproducing it in the body in itself.
Yeah, that's right.
Yeah.
So you try to make your written submissions stand alone. It can stand alone. You try to minimize the judge having to refer somewhere else. Sometimes you can't help it. If you can't help it, then at least have an annexure. So at the same time, the judge can read it without having to dig up some bundle from somewhere, from the trial. So make it easier for the judge.
Yeah.
It will put you in good stead. The judge will know that you are, it's almost as if you are being considerate.
I was going to say spoon feeding.
Anybody else have a question for Ken? Okay. Dawn has a question. Hey, Dawn.
Yes, thanks, Greg. Hi, Ken.
Hey, Dawn.
Hi, Ken. Thank you so much for speaking to us today. I think all of us have found what you've had to say really illuminating. And for me, myself, actually, I'm going to start putting your tips into practice tonight, pretty much. But so my question is this. I don't see it done very often, but do you think it's advisable to quote from academic journals? And if so, what's the best way to go about it?
You're talking about articles in journals, right? In the law journal.
Yeah.
Okay. I don't normally do it because I would rather have case law because of the principle of stare decisis, of course, right? But I can imagine there are instances when you might want to quote from the law journals or from a textbook, for instance, right? The first instance that I can think of is when there is, when on a particular issue, there is no established answer. Okay, the case law is divided. Then I would search out an article in a law journal or an author of a textbook that holds the view that I want to argue, and then quote from there. Another instance that I can see that happening is there's an amendment to the statute, right? So there's no case law on the meaning of the new words. So I would then go to the experts, look up articles, look up textbooks, you know, and so that you can have credence, you can have support for the argument that you want to make. So you want to argue that the new section or the new words in the section actually says this, and you have found authority in the form of an article, an author, one of the experts in their fields, agreeing with you. So it would lend support to your argument. But comparing case law and articles from law journals, of course, case law is much preferred. Does that help, Dawn? I'm not sure.
Yes, it helps immensely. Thank you so much, Ken. That answers the question perfectly. So I suppose it's a last resort sort of thing, isn't it? If I can't find the cases that if the cases don't say what I want them to say, then in that case, then turn to the academic journals.
Yeah.
Yeah. Okay. Thank you, Ken.
Ken, I had one, well, perhaps final question. Is there a particular judge whose style you think practitioners should adopt when writing a written submission?
I think Nazlan's structure is good, and his writing is good. I think that Azizul also has good structure, and he's very disciplined with his structure. Everything is headings and subheadings. I think Mary Lim writes well. Yeah,
because I was told when I first started, similar to what you mentioned at the start, to read Lord Denning's judgments and try as far as possible to adopt his style when writing, and so and you know that's something that we are taught in law school as well, to kind of like pick a particular judge whose judgments are short and to the point, and try your best to emulate that style.
Do you want me to talk about how you can improve your writing skills for purposes of written submissions? I'll talk about 3 points, right? The first is I think you can be a perpetual student of the English language and how to use it. So you will become a better writer, and if you're a better writer, your written submissions will be more effective, more persuasive, because of your command of the English language. The second is what I've talked about already, and that's précis writing or writing in summary. I think it wouldn't be a waste of your time if you go through the exercise of précis writing and use it like a mind sport for you. If you read a good passage in a judgment, in a case or an article, no harm spending like 5, 10, 15 minutes trying to summarize that passage into fewer words. And as you're doing it, as you're practicing it, right, you find that you will tend to be more brief. And the more brief you are, you tend to be more clear. It's all in the practicing, you know. So you might want to do that. It's like practicing writing executive summaries. And that's something that we have to do anyway in our work, right? Okay. And thirdly, it's you have to consciously and conscientiously apply these tips, these principles of better writing, of effective writing. Because if you don't apply them, you forget them. And if you don't apply them, you forget them, you're only stifling your own improvement. So to improve your writing, you have to make changes. And these are just a few of the many things that you can do.
Ken, thanks a lot. I think that's a perfect place to end the discussion. I think I speak on behalf of all of us to say that we are so grateful for your time today and your very, very insightful thoughts. Much like Dawn, I'm going to try to put it into practice tonight, irrespective of whether I'm drafting a written submission or not. But thanks so much, Ken. And we are so grateful for your time and the amount of effort you put into preparing for the talk as well as seeing your slides.
You're most welcome, all of you. You're most welcome. This is fun for me, so it's not work.
Thank
so
you,
you're not
Ken.
putting me off or anything. You're most welcome.
I can already foresee my associates striking out my submissions when I write in as much as after this.
Or you will be striking their in as much as out.
Yeah, something tells me they'll be striking mine out first. Thank you so much, Ken. Have a good evening.
All right, take care, everyone. Thanks.
Bye, everyone.
Thanks, Ken. Thank you.